Juvenile Justice Act from section 1 to section 10. Have you gone through it? Did you understand the knot making pattern? How to make knot, how to simplify the there act? So I am expecting that you will do the same for all the subjects. Reads Contract Act, NI Act, CRPC, CPC. You got the pattern of how to simplify the there act, then split it and write. And for exam, you will write in entire sentence form, the same thing. So can you quickly revise? Shall I ask you some questions? So in 5 minutes we'll revise from section 1 to 10. Who is abandoned child? When is the date of enforcement? Okay. Who is abandoned child? One person. Okay. Deserted by? You were not there, no? Last class? Okay. You go through the recording session, okay? And where is adoption defined? To subclause 2. What is adoption? It is a process by which a child is permanently separated. So see the words, permanent separation from whom? From biological parents and become the lawful child of adoptive parents. Now, what was section 10, last section which we did? When a police apprehend an accused juvenile, what is the procedure to be followed by the police officer? First what? Immediately hand over to whom? No, first one, child welfare unit or special police officer. Second step, immediately? Was judicial, not officer, juvenile justice board or any member. And the next step, shall not keep him in lockup or jail. Okay. Then if an unempowered magistrate, before an unempowered magistrate, if a CCL is brought, what is the procedure to be followed? First one, inquiry. Even the empowered magistrate will do the same thing, okay? But charge magistrate will do the same thing. They have to conduct an inquiry regarding the age. But in section 9, specifically provided for unempowered magistrate. So what is the first step? Inquiry about the age. Then he will collect the evidences. These evidences will be brought by the police officers. So what are the evidences? First one, birth, able to follow? First one is school certificate or equivalent certificate. If it is not there, then date of birth certificate from first attempted school. Third one,
date of birth certificate issued by municipal
or corporation, yes. And if all these three are not there, ossification test or medical test. Okay. We have studied 2 case laws also. Okay, refer. Vishnu versus State of UP. State. Okay. And the other one? Shanawaz case. And I gave you one homework, no? Read the powers and functions under section 8. Have you gone through it? Section 8, what are the powers and functions of the board? If you study the entire section 1 to 26, now you will be able to study the powers and function. First one I will tell in short, conduct inquiry. Inquiry regarding age, inquire whether he has actually committed offence. Okay. First one is conduct inquiry. Next one is adjudication and disposal of case. Adjudication of case means? Adjudication, section 8. I am telling in short. Adjudication of case means? Adjudication means to decide the case. Dispose the case? Decide the case. Next one. There is a probation officer appointed under the JJ Act. Okay. And once he is appointed, now when a juvenile is brought before the court, first step the juvenile justice board takes is they will call for a social investigation report. Ma'am has taught you, know. So when a child is arrested and brought before the juvenile justice board, the JJB will simultaneously ask the probation officer to prepare a social investigations report. So what is there in the social investigation report? Yeah. What are the circumstances that led him to commit crime? Is he from a good family background? Is he attending the school regularly? Is he in bad company? Is he associated with habitual hardcore criminals? Okay, all these things. Social investigation means investigation of his surroundings. Okay, that will be prepared by whom? Probation officer. And within 15 days of production, when he is arrested, within 15 days probation officer has to submit the report before whom? Before JJB. Got the process? That is also a procedure. Next one, board has another power, visit where they stay. Visit juveniles are kept in, child in conflict with law is kept in observation home sometimes. Sometimes he is released on bail. Then where to visit? Visit his house. Okay, visit his house, visit his surroundings, visit the observation home. This is also a duty of Juvenile Justice Board. Members may not go, members may delegate other officers, other court staffs to go and visit and give a report to the JJB. Got the point? Next one is inspection of jails. Inspect jails. Inspect jails means jail is a place where above 18 people are. Once some verification should be done whether they are having any connection with juveniles. Inspect jails where adults are kept. Are you able to follow? Able to follow? Should I be slow? You listen to the recording classes once, okay? So inspect jails means conduct an inspection in the normal prison and find out whether these above 18 prisoners are having any contact with observation home. You know, some phones are also carried in jail. You know that? They are not having, but police officers, no, they you know it, right? So this kind of any kind of association with big criminals and juveniles, that is one inspection. Legal aid you might have studied in law college. What is legal aid? If he provide free and legal service. Some children will be abandoned children having committed crime, or in railway station and all we can see petty small criminals. Are they able to engage a lawyer for themselves? No. So board will once he is arrested, appoint from the legal service authority. There is a panel of lawyers in every district who has registered their name in the legal service authority. They will get a nominal fee. Suppose like in Kerala now it is 5,000 or something. So a nominal fee, and here also there will be a panel in every district. The district legal service authority will fix an stipend to be provided to the lawyer, and who are interested in providing free legal service will provide legal aid to the juvenile. Got it till now? Any confusion, Nagendra? Okay. Next one is parents' participation in case. They ensure that the JJB ensure that parents also appear along with the juveniles, because ma'am has already taught the principles of the juvenile justice system, no, to reform them, to rehabilitate them. Parents' participation is also necessary. So next point is parents' participation in case. Next, what is the power and function? If the child doesn't know the language, no, suppose a child from Kerala, he has travelled in train without taking a ticket, in the form of committing begging. He landed Tirupati, and now he landed here. He engaged with other criminals and he is committing crime in Tirupati. He is caught by the Tirupati police. His mother tongue is Malayalam. He doesn't know Telugu. He has committed offence in Andhra Pradesh. So he will be tried in Tirupati court only. When he is brought before the magistrate, no, brought before the JJ will come to know that he doesn't know the language. Now he also his right is to be protected, no. Even although he is an accused, his right is also to be protected. So we will keep an interpreter or translator for him. Usually advocates who speak Malayalam, no, or advocate who speak the language which the accused CCL speaks, he will be appointed as an interpreter or translator. Or if no lawyer is available to interpret or translate, any other member who has proficiency in both the languages. They have to communicate with the judge also, they have to communicate with the juvenile also, will be appointed. Till now, no confusion? Next one is ensure that child rights are protected. You know it, no further explanation. And if the child is a victim, no, after thorough investigation, after going through the social investigation report, if the magistrate, if the JJB is of the view that that child is also a victim, if he is forced to commit begging, if he is forced to commit petty offences, he is also a victim, no. So tell him, help him to lodge an FIR. I have a son. I am into begging and I am into committing big crimes in the society. I have a child. Although he is not interested from childhood, no, I am training him and I am forcing him to commit offences. He has committed offence. Now he will be independently dead. Then police catch hold of him. All the section section 9 procedures, section 10 procedures will be complied. After due inquiry, magistrate will come to know. Social investigation report also came in hand of the JJB. JJB comes to know that all these offences are committed because of parents' influence. Now he is also a victim, no? He is victimized by whom? Parents. So lodge and help him to lodge an FIR against the parents also. Till now any confusion? So you will conduct enquiry, adjudicate, dispose the matters, social investigation report within 15 days of arrest. By whom? Probation officer. Visit the place where the juvenile is staying. Visit the jail and make sure that he is not acquainted with the 18 plus criminals. Next one, legal aid. If he needs legal aid, provide him legal aid. Parents, ensure that parents are also actively participating in the case and getting updates of the case. Next one, if the child doesn't know language, translator or interpreter. Ensure that the child rights are protected. Able to follow? Okay. And next one, if he is a victim, help him to lodge an FIR. Go through the section and make short notes like this. Okay. Now next important section is section 12. What is section 12? Bail to CCL. You write bail to CCL. Can you define in simple words what is bail? A person is enlarged on bail means he is released on bond or without bond, he is released, that is bail. And CRPC categorizes bail into two types. What are those? Bailable offence and non-bailable offence. Bailable offence means those offences which are shown as bailable in the first schedule of the court. First schedule, when you see the barrack, no, last you will see schedule 1, schedule 2, schedule 3 in every barrack. So in the first, see the last schedule, anybody having? No, you don't have CRPC with you, sorry. So in the CRPC, every barrack got one or the other schedule, okay. So in the first schedule of the CRPC, they have categorized offences of IPC. Suppose theft is a non-bailable offence. Any bailable offence? Example of any bailable offence? Defamation is a bailable offence. So bailable, cognizable or non-cognizable, one schedule is given. So those offences which are scheduled as bailable are bailable offences. Bailable offences means less grave in nature, less grievous in nature. Which are very much grievous are non-bailable offence and generally cognizable offences. Cognizable offence means an offence where, am I talking fast, pace is fine. Cognizable offence means an offence wherein police officer may arrest a person without warrant. That is also grave offence. Bailable also, non-bailable is generally cognizable. Bailable is generally non-cognizable. It can happen otherwise also. So there are two kinds of offences, bailable offence and next is non-bailable offence, both. And some acts define bailable and non-bailable offence. For example, NDPS Act. NDPS Act specifically says which offences are bailable, which. So you don't have to follow IPC or CRPC for that. POX, Special Act specially prescribes. That's why the Act says bailable either mentioned in the first schedule or under any other law. Got it? And but in case of CCL, no, and bailable offence means the person has right to bail. You get bail from the police station. Sometimes magistrate gives bail also. Non-bailable offence means it is the discretion of the court. Because offence is grave in nature, police officers will file remand application. Police officers will file report when a person is arrested and brought before magistrate. For further inquiry and investigation, we want the accused in custody. So he will be detained in custody. Defense counsel or the accused counsel will keep on filing bail application only when the magistrate, only when the judge feels that it is okay to give. It is okay to give bail, or if the investigation is almost completed, or if he is sent out in bail, he won't create that much harm to the witnesses or other persons, he will be granted bail. Non-bailable offence, it is a pure discretion of the court to grant bail. Bailable offence, it is a right of the accused to get bail. Got the difference between bailable and non-bailable offence? Now you write bail to CCL. Juvenile is entitled to bail. I shall explain to online. One student has asked what is the difference between abandoned child and surrendered child. What is the difference between abandoned child and surrendered child? Abandoned child means a child is found abandoned. What was the definition of abandoned child? A child who is deserted. A child who is deserted. A child who is left out without parents is abandoned child. Surrendered child means he has parents, but he has guardians, but they are unable to maintain that child. For example, I am sick. I don't have anyone in family. I have a child. I don't have in-laws. I don't have my parents, grandparents, siblings. No one to take care of my children. I will surrender the child to the child welfare committee. Abandoned child means already that child has no one. Okay. Surrendering means I am giving up. So bail to CCL. Juvenile is entitled to bail. Able to follow? Juvenile is entitled to bail notwithstanding the seriousness of offence. That means for bailable and even in non-bailable offences, a CCL has the right to bail. Right to bail. CCL is child in conflict with law. For exams, you write child in conflict with law. What happened last? Fine. Completed. Next one. He shall be released on bail with or without sureties. He shall be released on bail with or without sureties, or placed under the supervision of probation officer, or under care of any fit person. Bail will not be granted. Bail shall not be granted only if the child in conflict with law, you write CCL, only if CCL associate with other criminals. So what you understood by this? Be it bailable offence or non-bailable offence, juvenile, a person below 18 years of age, has the right to get bail. So then what happens? What is the procedure? Either he will be released on bail with or without sureties. That part we will see in CRPs, BNSS. Okay. As of now you understand, he will be released on bail with or without sureties. If there is no surety, suppose he was already a surrendered child abandoned child committed offence, or if he has no one to come as a surety for himself, what happens? We will place under observation home, but it is under the supervision of probation officer or under care of any fit person. Fit person, it can be guardian, parent. Okay. So he is either released on bail or kept in observation home under the control of probation officer, or under any fit person. It can be any place of safety also, under care of any fit person. Now if he is not released, in which case he is not released? If he is associated with other grave criminals, if he is associated with other criminals, he is not released on bail. So then what is the procedure to be followed? First one, if he is not released, subheading. Before I said no, refuse when bail is not granted if he associate with criminals. One more ground is there, moral, physical, psychological danger. If he is released, no, he will cause moral, physical, psychological danger. What happened, Nagendra? Now if he is not released, what will happen? First one, keep in observation home of or place of safety. If the CCL, next point, if the CCL keep in observation home or place of safety. These are the steps to be followed if he is not released. Why he is not released? Because he associate with criminals or moral, physical or psychological danger occurs if he is released. Now if he is not released, keep in observation home or place of safety. You can imagine and right now what happens if he is not released. He will be kept in observation home or place of safety. Next one, first point we read now, he is released on bail with or without sureties. Suppose bail order is passed, bail conditions are there. He is after hearing the defense counsel and prosecutor, no, bail application is allowed by the JJB. So what is the procedure next? Bail order will be passed. In that bail order, conditions will be there. Do you have in your judiciary syllabus writing orders or only judgment writing? No order, no interim orders writing. Okay, in the bail there will be conditions. He shall not commit further offences. This will be there. He shall not go abroad. If passport is there, he shall surrender the passport. He will not tamper any evidence. He will not what to say, engage with the victim. What is the exact word? He will not try to contact victim. All these conditions will be there, and for all these conditions we are and he shall attend the court and police station when he is called for signature, and he shall execute a bond with 2 solvent sureties of 50,000 rupees each, like that. So if he fails to bring sureties, what happens? He can't execute the bond. How bail applications are executed? Have you gone to court and saw it? Bail order is passed. Now you have to execute the bail order. Leave the JJB part. I am an accused. I have committed a crime. I was detained in jail for 15 days. My advocate filed bail application. First bail application, magistrate heard. Magistrate is satisfied that he can be released on bail because investigation also completed, and prima facie investigation completed. He can be released on bail. So bail order is passed. With this in the bail order, one condition is there. With along with other condition, one more first condition will be he shall execute a bond with 2 solvent sureties of rupees 50,000 each. Sureties of 50,000 means those persons should have immovable property in their name. They will bring the tax receipt. That is the execution. This bail order is there. Next process is I will go to the court. My advocate will go to the court along with the bail order and 2 sureties. First condition is bring 2 sureties. No, those sureties are sureties who have immovable property in their name. Because 50,000, if I don't come, no, if I don't appear in the court, they are giving surety. In contract, you see surety. You will come in. Surety means a person who guarantees. He is giving guarantee. If this accused won't come, no, I will bring him to court. If he doesn't come, you can take 50,000 from my property. That is what you are able to follow. So this condition will be there. Then what the magistrate will do, what the defense advocate will do, he will present the bail order, he will present 2 sureties and their Aadhaar card, their tax receipt and other affidavit, all those things. This will be submitted and he will be granted bail. This will be taken to the prison. We will get it verified to jail officer. he will release the accused from the jail. This is the normal procedure. Same way in JJB, instead of jail, where he is staying? Observation home. He is staying in observation home, but he is unable to fulfill the condition in 7 days. Bail order is passed in his favor, but for 7 days he is unable to bring surety. Then what happens? Bail will be cancelled. But here bail he will be produced before the board again for modification of bail. Bail won't be cancelled. Bail will be like that. He will be in prison until you bring the surety. Generally for 18 plus adults, bail will be allowed, but bail won't be cancelled. He will remain in the jail. Only if he fulfill the conditions, he can come out. First condition is bring 2 solvent sureties, right? So if CCL is unable to fulfill condition, in 7 days, produce him before the board for modification of bail, full stop. So you got the bail procedure. Bail is allowed, be it bailable offence or non-bailable offence. In juvenile, he has the right to bail, and bail is not given only if he associate with hard criminals, and if we release him, the board feels that it will cause psychological, physical or mental danger, moral danger. Next one, if he is released, what are the conditions? He shall be released with or without sureties. Next one, if or else he will be placed under the supervision of probation officer, or he will be kept under the care of any other person. If he is not released, he is kept in observation home, and already bail is allowed, but he is unable to fulfill the conditions. Within 7 days, he will be again brought before the board to modify the condition. That first part they will remove, maybe. Okay. Maybe instead of 2 surety, they will reduce to 1 surety. Some modifications will be done according to the facts and circumstances. Next, what is section 13?
Information to parents, guardians or probation officer.
That is when a CCL is brought to child welfare police officer or special police unit, inform the parents or guardians. We have right to right of arrested person in CRPC, that if a person is arrested, immediately you have to inform the nearest relative or friend or guardians. The same thing, when a juvenile is arrested, you have to immediately inform the parents. Who will inform? Child welfare police officer or special police unit will inform the parents that your child has committed offence and he is brought before the board. And second thing, probation officer has to compulsory file a social investigation report. For example, in prelims, if they ask what is the report which is to be filed by probation officer, social investigation report. Social investigation report means juvenile's facts and surroundings will be observed and recorded, and what made him to commit an offence. All these things will be considered. And when the CCL is released on bail, along with the parents, probation officer is also informed, because continuous supervision will take place. Section 13 simple, it won't be asked. Section 14 is enquiry by board regarding CCL. That is, whenever a child in conflict with law is produced before the board, compulsory he has to hold enquiry. Same thing regarding the what led to commission of offence. Is the allegation against him is true and correct? Is he of the correct age? If he is complying the age thing. So all the inquiry has to be completed within 4 months from date of first production. Suppose today a CCL is produced before the JJB, he is arrested, and from today within 4 months the inquiry has to be completed, and further extension will be given in extra. Suppose I told from Kerala he is coming to Tirupati and committed offence. So it is difficult for the police officers. Police officers will be directed to do the inquiry, all other work. Probation officers are directed. It is difficult to complete because they have to identify the circumstances in Kerala also. Some cases are pending there also. Some reports are to be taken from the JJB there also. So 4 months can be extended to 2 more months. So in total 6 months. But when they ask the question, no, you have to answer 4 months. Then in exceptional cases, additional 2 months time will be given. But in case of heinous offences, what is heinous offence? More than 7 years. Imprisonment more than 7 years. In case of heinous offences, preliminary inquiry is to be completed in 3 months. And if more time is needed now, you have to get permission from the Chief Judicial Magistrate or Chief Metropolitan Magistrate. And for petty offences, if the inquiry is not completed in 4 months and 2 months now, proceedings will be terminated. What is the result of termination? No trial, nothing will be there. But usually inquiry will be completed even in petty offences. So regarding the inquiry, can you revise now? Inquiry is conducted as soon as he is produced before the board. What is the time period to complete? 4 months. In exceptional cases, extension for 2 more months from date of first production. So in prelims, now that question will be asked from date of first production. So underline that 4 months from date of first production and further 2 months. Understanding? Any doubt? Next one, in case of heinous offences, how much time? 3 months. If it is not completed in 3 months and if you need more time, whom you have to depend? JJB has to get permission from Chief Judicial Magistrate or Chief Metropolitan Magistrate. And petty offence, if it is not completed in 4 months, what is the result? Proceeding will be terminated. So only these 4. And some steps for fair and speedy trial is given in the Bear Act. That also you just read. First one is child friendly atmosphere. We studied it should not be intimidating. Venue should be, courtroom should not be intimidating, and it should be child friendly. So child friendly atmosphere, entire process, investigation, inquiry or trial, entire process will be child friendly. Next one is ensure that no ill treatment is made by the police or lawyer or probation officer. They are kept in observation home, no? They should be treated as children and they should not be ill treated. No kind of violence should be made on them. So ill treatment by police, lawyer and probation officer should not be there. That should be made sure. Next one, for petty offences, summary proceedings. In BNSS, when we come to now you just keep in mind petty offence, summary proceeding. But when we study BNSS, we will see summary proceeding in detail. Next one, in serious offence, summons trial. Next, in heinous offences, if the offender is less than 16 years, no, it will be treated as a summons case. Summons trial will be there. If the person is above 16 years, preliminary inquiry will be conducted and tried as a summons case. Some amendments ma'am has discussed, no? 2013 amendment after the Verma committee report. If a person has committed a heinous offence above 16, he will be treated as an adult. So you just note down one point: petty offences, summary proceeding. Serious offence, summons trial. Next heading, heinous offences. Heinous offence, juvenile less than 16 years, summons trial. Juvenile above 16 years, conduct preliminary inquiry, summons case. So you got an idea how inquiry is conducted by the board. Next important section is section 15. Section 15 you read it along with the notes, okay. Preliminary assessment to heinous offences. If a child is above 16 years and he has committed a heinous offence. Heinous offence means offence where imprisonment is above 7 years. So a child above 16 years has committed a heinous offence. So the board has to conduct compulsorily a preliminary assessment. Preliminary assessment is nothing but preliminary inquiry. One more additional inquiry will be there. That is inquiry on what all things. First one, circumstances that led him to commit offence. So you write child above 16 years. In short you write child above 16 years committed heinous offence. Next point you write conduct preliminary inquiry. How they will conduct preliminary inquiry? Verify the circumstances. So first point you write circumstance. Subheading. Yesterday I told you know how to make circumstance. Next point, mental or physical capacity. Next, whether juvenile has the ability to understand the consequence. Whether juvenile has the ability to understand the consequence of his act. So that is the first point under section 15. If a child has committed a heinous offence who is above 16 years, compulsory a preliminary assessment or preliminary inquiry has to be conducted by the board. They will take the help of probation officers and other officers. And inquiry, on what basis inquiry is conducted? They will verify the circumstances of the case that circumstances that made him to commit the offence. Suppose he okay. Next one is mental or physical capacity of the offender. Next one, whether he has the ability to understand the consequence of his act. Next one, for conducting the inquiry, board has to take the help of some people. Who are those people? Psychologists. So you write the next point, board take assistance. Board take assistance. I hope online students are able to follow. Please reply someone in the chat box. So board take assistant. First one, psychologist. Second point, psychosocial worker. Next point, other experts. Other experts like lawyers. Nagendra, any doubt? So till now no doubt. Women also. Heinous offence. Have you seen practically? But the same thing applies to male and female. And if it is found that he is not a CCL, what will be, how he will be dealt? He will be sent to the ordinary court. So that is the main thing in section 15. So you should read the Bare Act. Go and read the Bare Act. Okay. Now what are the orders for CCL? What is the next section? 16. Review of pending cases. You need not study. That is administrative section. That is CJM will verify. JJB will come under the administrative control of CJM. So CJM or CMM will verify whether things are going, whether how disposals are taking place. That is not important. Which is the next section? Orders regarding a child not in conflict with law. Somebody read the Bare Act section. Orders regarding section 17.
Child not found to be in conflict with law. Where a board is satisfied on inquiry that a child brought before it has not committed an offence, then notwithstanding anything contrary contained in any other law for the time being in force, the board shall pass an order to that effect. Next. In case it appears to the board that the child referred to in subsection 1 is in need of care and protection, it may refer the child to the committee with appropriate direction.
So two things, you can find two steps here. So order regarding a child not found to be in conflict with law. So what is the first step? He will be released. That is what the first provision says. He will be given and released, in the sense he will be handed over to the appropriate custodians, be it biological parents, adoptive parents or guardians. Next thing, if he is a child in need of care and protection, then he will be handed over to the place of safety or open shelter, not observation home. Any appropriate directions will be there. Suppose a child who is living in open street, they had a doubt that he has committed an offence, but after enquiry it came, the board concluded that he has not committed any offence. He can't be sent to his parents because he doesn't know where his parents are. So board will make appropriate orders. He is naturally a child in need of care and protection, so he will be sent to open shelter or a place of safety or special home. That is what section 17 says. Now section 18.
Orders regarding child found to be in conflict with
You write the note, this is lengthy. First, allowed to go home. After advice or admonition. Second point, counseling, allowed to go home after advice or admonition. ADMONITION. Admonition means warning. Allowed to go home after advice or admonition. Next point, counseling to CCL and parents. Third point, be fast, group counseling. Next, order to perform community service. Pay fine. Next one, pay fine. Next, direct to release on probation of good conduct. You pronounce as conduct or conduct? Conduct, both. Okay. On probation of good conduct. Next point, place under the care and protection of parents, guardians or a fit person up to 3 years on bond. BOND. Place under the care and protection of parent, guardian, fit person. While telling important notes, okay, I shall repeat. Fit person up to 3 years in bond. Next one, direct him to special home for reformative services. Online students, you want me to repeat the same thing? Order for CCL again. The points, reformative services. Meenakshi has message while telling important notes, please repeat. Are you able to follow these points? Orders for CCL section 18. Yes, okay. So order for CCL, first one is allowed to go home after advice or admonition. A child is arrested and brought before the board. So what is the first step? When he is released on bail, he will be given advice and admonition. Admonition means warning. Advice means, advice or admonition. Second one, second order which may be passed is direct for counseling. Is direct him to a psychologist for counseling. Counseling, it can be for CCL separately and for parents separately. Next is group counseling. Parents, guardians and the CCL will be brought together for a joint sitting, joint counseling. Individual counseling, joint counseling, send him with due admonition. Next one is community service. Order to perform community service. That is to reform him. Community service is a new punishment included in BNSS. Earlier in IPC we had 5 kinds of punishment. That is death, imprisonment for life, imprisonment, rigorous or simple, forfeiture of property, fine. Now we have community service added. Community service is not defined in BNS, but you will find a definition in CRP BNSS. Okay. So community service means examples of community service: plant trees, to juveniles plant trees, serve in the hospital. We have the Swachh Bharat Abhiyan similarly, or what else? Any community service example? Any online students can give example of community service? Offline students? Huh? Social activities.
Helping in old age homes.
Helping in old age homes, helping in NGO. So tell him to perform some community service so that he will be little orderly. Okay. Reform. Next one is pay fine. For petty offences, usually impose fine and release him after due admonition. Next one is place direct to release on probation of good conduct. Probation of good conduct means tell him to enter into a bond. There is probation of offenders act. In probation of offenders act in section 4, you don't have it in syllabus, I think. A person committing some offences under 379, 380, 381, 382 of IPC, like theft, 380, robbery, all these offences. Now if he is doing it for first time and if no previous conviction is also proved, he will be sent in he won't be sentenced. He is found guilty, but first time he'll be given a second chance. So he will be asked to enter into a bond and go just like parole, not parole, he will be released on bond. That in this 3 years period, if you commit any offence, you have to receive the original sentence. That is probation on good conduct. But here direct to release on probation of good conduct means ask him to enter into a bond for keeping good behavior and release him. Next is place under the care and protection of parents, guardians, fit person up to 3 years bond. Somewhat like probation of good conduct, only same thing. Next one, if he has no one, if he is also a child in need of care and protection, send him to special home for reformative services. Order for CCL. Next important section is, almost we have completed all the things. Remaining sections are, you can verify the notes also. Next one, runaway CCL. Where is runaway CCL? 26. Section 26, runaway CCL. You write. Section 26. A child is kept in special home, or a child is kept in observation home, or a place of stay, safety, or any institution. We have studied the different child care institutions. 7 child care institutions are there. That child ran away from the institution, because that is also, it is just like a hostel, no? There is discipline. Children have the tendency to come out of it. So they run away, they are called as runaway CCLs. From there, where they ran away? From child care institution. It can be special home, observation home, place of safety, institution. If a child is found outside who is the runaway CCL, first thing is the police officer has to immediately produce him within 24 hours before the board or nearest board. Now what board will do? He ran away. First step, he ran away. From where? From child care institution. What police officer has to do? Within 24 hours, produce him where? Before the board. What board has to do? He has to conduct an inquiry. He has to find what are the reasons that led him. Maybe it may be torture, POXO offence. It may be an offence. Suppose the CCL is a victim to POXO offence in the observation home, or if he is tortured, harassed, anything can happen, right? So ascertain the reasons, whether he is safe if we send him back again, and send back. No additional proceedings will be there. He won't be charged for escaping from there. If a person escape from jail, there will be proceedings. Strict measures will be taken. But for runaway, they are children, no? If they ran away, just call them back by police officer. Inquiry will be conducted by the board. They will be sent back to the institution, place of safety if it is safe. If it is not safe, they will be placed somewhere else. and no further proceeding. That is runaway CCL. Section 23 is important. No joint trial with adults. You write, that's it. No joint trial with adults.
What if the police didn't caught child?
He will be absconded. Then the same procedure we see in CRPC, no? Proclaimed offender, absconder, these procedures will apply. We will study that in CRPC, we will connect it. Now usually children, now you can find them, they won't go that far. Section 23, no joint trial for adults, no joint trial with adults. JJB is different, ordinary courts are different. Section 24, effect of previous conviction. You write it, effect of previous conviction. Now write the heading, removal of disqualification on the findings of an offence. That is, it is proved that he committed an offence earlier. He will not suffer any disqualification. I told you about Probation of Offenders Act, no? For first time offenders, if an adult, he has committed offence under 379. He has done it for first time. No previous conviction is proved against him. Only if no previous conviction is proved against him, he will get the benefit of Section 4 of the Probation of Offenders Act. Section 4 of the Probation of Offenders Act says that for certain offences, they have enlisted the offences 379, 380, 381, 382, 383 of IPC committed for the first time. No previous conviction is proved. Then the court will send for probation on good conduct. That is, no sentence, you will be released on bond. Don't commit any further offence. But if he is a third time offender, will he get probation of good conduct benefit? No. But for juveniles, no, even if he is a repeated offender, even if previous conviction is proved against him, he will get the benefit of probation. That is what first, no, you write effect of previous conviction hyphen, he do not suffer any disqualification. Next point, court will direct police and its own registry REGISTRY to destroy the records of the case after the appeal period, after the expiry of appeal period. Next point, for heinous offences, relevant records shall be kept in children's court. Shall be kept relevant records for heinous offences, relevant records of the case shall be kept in children's court. So what is the effect of previous conviction? Even if he is previously convicted, he will get the benefit of Probation of Offenders Act and all other acts. Okay, that is one thing. Second point is, all the case records, no, case file, it will be destroyed after the appeal period. Appeal period, suppose 90 days is the appeal period. Till 90 days that will be kept in the registry. Registry means court office, the administrative section. It will be kept safe in the registry, and after 90 days, after the period of appeal, the same shall be destroyed. Police will also destroy the records, means that will be irrelevant. Next one is for heinous offences, no? Heinous offences means offence where 7 years imprisonment, records won't be destroyed. In the children's court, the same shall be kept in a file. Got it? These are only the important sections. And tomorrow, no, for half an hour I will deal with adoption, child welfare committee and all. That is not that important, but in case if it is asked, you should be able to answer. In one line will complete. You take a break. After that, I think ma'am will take. I am planning to take DV Act also, the definitions today.